Well, good afternoon, everybody. I think we're about to get started here, and I'm going to wait just a couple more minutes for some more folks to join us. So I'm looking forward to kicking this off in another minute or so. Thank you. Right, I think I'm going to go ahead and get started, and people may join us as we get going here. My name is Julia Weber. I'm an attorney and social worker, and I work now as a consultant nationally on gun violence prevention efforts, including focusing largely on the intersection of domestic violence and firearms violence prevention efforts, as well as emphasizing the need for robust, fair, equitable, effective implementation. Before I began in my role as a consultant full-time, I worked for several years with Giffords Center to prevent gun violence, which is located here in San Francisco, California, where I'm coming to you from today, where I live and work. And the Giffords Law Center is part of the National Giffords Organization. I founded the first gun violence prevention organization's focus on implementation there, where I was director of implementation. And I now consult with Giffords nationally on legislative efforts and implementation, and with several other gun violence prevention and domestic violence organizations, with courts, and do a lot of national training and speaking on the topic. I have been really lucky to have the opportunity to join some of the other presentations that have happened as part of this impressive conference that you all in Michigan have put together. And I've had the pleasure of working with Ryan Bates and others in your state, Dr. Zioli, in my role previously with the Battered Women's Justice Project as well. So I am really happy to be here and welcome the opportunity to talk with you about these issues today. We come to this work as I probably don't need to explain to this audience, often with personal as well as professional connections. And I think it's important to draw attention to the survivors and the victims that have helped shape my role in this work. One of them early on when I was growing up in Arizona was the murder of Elena Steinberg in 1981 when I was 14. And Alana was a member of a synagogue that I was also a member of, a parent of a child who was around my age, and was tragically stabbed to death over 20 times by her husband at the time. He initially claimed that she had fallen out of bed and fallen onto the knife, and then eventually admitted to having killed her in their home. The subsequent trial eventually led to his acquittal. He defended himself by using what was referred to as the Jewish American princess defense. That is, that her nagging, excessive shopping, her personality, certain stereotypes about Jewish women that were particularly significant at the time led him to a sort of insanity that resulted in him murdering her. That case had a profound impact on me, and while it doesn't directly involve firearms, obviously the focus of my work on domestic violence was shaped by that horrific tragedy and the subsequent judicial proceedings. Later on, when I started working in San Francisco between college and graduate school, I became acquainted with Jack Berman, who was an attorney in San Francisco, a civil rights activist, and who happened to be at 101 California in the mid-90s when a mass shooting happened at a law firm there. And Jack tragically was killed in that shooting. He had an 18-month-old son and a wife, Carol Kingsley, who went on to help form the Giffords Law Center. Then it was the Law Center, focusing on changing California's laws and national federal laws around gun violence prevention in the wake of that horrific tragedy. And so I think about Jack too when I do this work. And then raising my own son, who is a young African-American male growing up in San Francisco, where we raised him, and of course had to worry about and confront the disproportionate impact of violence on young men of color. We've lost way too many people. We've known young people with amazing, bright futures ahead of them, including Kieran, who was someone my son went to school with, who was shot and killed playing basketball one day in the neighborhood next to ours. And then I think of Pauletta Perez, who is a survivor, a woman who was living with her husband, who was emotionally abusive. She was experiencing domestic violence, and one day he pulled out a firearm that actually had belonged to her husband, her father, I should say, who had given the firearms to her husband to hold them for safekeeping. And he used one of those firearms to shoot Pauletta in the head. She amazingly was able to escape and has survived that shooting and has gone on to turn, as she talks about, her pain into purpose, and has an incredible blog post at the Giffords website. And I'm honored and privileged to work with her when I have the chance. All of these represent stories of survivors. I know we have survivors and those who've experienced victimization joining us here today, as I do at all of the talks I do. Their experiences, I think, are so central to how we do this work. Our own experiences, having lost people or working closely with courageous survivors who have tried to make a difference in our communities. And they also reflect different types of violence. And one of the things I'm most interested in is what we can do to not only effectuate good policies, as you all in Michigan should be very proud of, most recently with some of the significant changes you've made, but how to implement them and how to leverage those tools in ways that will actually make a difference and accomplish what we're all setting out to do in these contexts. So California is an example I use often, not just because I have lived and worked here for over 20 years, but also because it's a place where there are a lot of opportunities to enact certain gun violence prevention provisions. It's a large state, some say the sixth largest economy in the world, with the largest court system also in the world. So you have a diverse population, some of the largest urban centers with Los Angeles and Orange County, significant influences in terms of cultural phenomenon influencing Hollywood, television, so forth. We also have some of the smallest counties and more rural counties in the country, and firearms are present in our urban centers, in our rural environments. People often think it must be easier to work in California, less of a so-called red state. The reality is that the gun violence phenomenon is affecting all of our states, rural, urban, north, south, west, east, and impacts folks in different ways, of course, across race, class, culture, and gender. But this is a story that was done a few years ago in 2019 about California's domestic violence firearm laws. We have had in California state firearm violence policies addressing the intersection of domestic violence and firearms prior to the federal prohibition. So we were one of the states that restricted access to firearms in civil domestic violence restraining or protective order cases even prior to the changes in federal law, so before the mid-90s. And yet, we still saw very limited implementation and tragedies such as the case of Callie Garay, who was a mom who had young children, who was experiencing domestic violence, went to the court to request a restraining order, submitted paperwork in her declaration, which was 12 pages, describing extensive abuse, including threats with a firearm, her husband bringing the firearm to school to threaten her when she was bringing the kids to school, his ownership of multiple firearms. She reported all of that in her restraining order paperwork. The judge granted her request for the restraining order, which in California results in an automatic prohibition. It also required, at the time, certain procedures in terms of relinquishment and review of his compliance with the firearm prohibition, but demonstrating that the judge probably did not read Callie's paperwork. The judge said on the record from the bench, I know you've become prohibited, but I don't see any evidence that you currently own a firearm, so no worries about that, basically. And within a few short weeks after that, he found her outside of a doctor's appointment that he learned about by contacting the doctor, and the doctor revealing information. We've subsequently changed some law in that area as well. And he shot and killed her in front of her young children. Cal Matters did an extensive investigative journalism piece on this that really helped shape some changes that were made in California to develop relinquishment processes and procedures, a piece of legislation called SB 320. You can check out the story there. I highlighted here, obviously it's another state, has some relevance, but not completely applicable. But to point out that even in places where we have had success in developing these really important policies, we have to be vigilant around implementation. We have to be vigilant around training, around getting information out about these remedies, around ongoing compliance, accountability, expectations for our state actors to be fair and appropriate, and also to address ongoing bias in this area. Another example of a situation that I think is really worth highlighting is Officer Valerie Martinez in Louisiana, who has worked diligently to ensure that firearms are removed even without extensive state policies regarding relinquishment procedures in the domestic violence context. Officer Martinez has worked with the FBI, with federal prohibitions. Now, given the US versus Rahimi case, there's some restrictions, of course, on implementation of the firearm prohibition, and I'll talk a bit about that. But Officer Martinez told an amazing story at a training a couple of years ago about in the middle of being in shelter during a hurricane, trying to get cell phone service, Wi-Fi access so that she could work closely with the FBI to ensure effectuation of prohibitions so that firearms could be removed appropriately in a domestic violence case. Her dedication is incredible. She's also pointed out that, officers have various options when proceeding with firearm prohibitions or cases involving firearms in response to concerns where some officers have said we can't manage to store firearms. She'll note that you can store them either now or when they become evidence after a horrific tragedy. So really emphasizing the important role law enforcement plays in implementing some of these procedures. But I also want to point out that, and I'll talk a bit more about this in a few, that we have found in a place like California and in other jurisdictions that having a range of tools available is critical. And now Michigan has more tools than at other points in time, and some other things to be thinking about going forward, as has been pointed out in some of the workshops that I've had the opportunity to attend today. So this is just an example here again in California of some of the various ways that we have developed tools that can be as refined as possible to address the various types of situations that may involve access to firearms and various types of violence or potential violence. So we have firearm prohibitions in the domestic violence restraining order context, or your PPO in Michigan, at the emergency stage when law enforcement may arrive at the scene and contact the on-duty judge to get a short-term order, usually lasting 14 days. Those are firearm and ammunition prohibiting. Also at the ex parte or temporary restraining order stage, pending a full hearing, firearm and ammunition prohibiting. And at the order after hearing stage. So after there has been a hearing, the person's been served, there's been a hearing, and an order like the one that should have protected Cali goes into effect, firearm and ammunition prohibiting under state law in an even more robust way than under federal law, as it includes dating partners, which the federal prohibition is much more limited around. Similarly, elder abuse restraining orders, same kind of restrictions, civil harassment orders for strangers, neighbors, stalking might show up under a domestic violence restraining order or under a civil harassment restraining order. Workplace violence prevention orders, again, focus specifically on issues related to threats and abuse within the workplace. So for employers, employees, firearm and ammunition prohibiting, all of these civil orders are. All of those 4 orders name specific protected parties. But back in 2014, when the first modern ERPO law, extreme risk protection order law, as we know them now, came into being, California was the first state to develop an ERPO that allowed non-law enforcement folks to petition the court for this kind of protection. And that is the gun violence restraining order. That's the version of the ERPO in California. So that added another tool to the toolbox for situations in which you don't need to name a protected party. So there's no name protected party the way there is in these other civil orders. There is only a petitioner who's seeking to restrain the respondent's access to firearms and ammunition. So it restricts only their behavior around owning, possessing, or purchasing firearms and ammunition. 96% of these orders have been sought and obtained by law enforcement. So only 4% have been sought or obtained by non-law enforcement, even though it was designed to allow, of course, household members, family members, and has now included employers and certain situations involving school personnel. So the GVRO, or that ERPO tool, became really important as a gap filler and as one that was really focused on addressing suicide prevention and mass shooting situations. And we have a lot of research that's been conducted in California that has shown that in cases, many cases involving threats of mass shootings, where GVROs were obtained, those mass shootings did not occur. So there's good reason to believe that as a gap filler, it has played a very important role. It has also allowed us since 2014, when it was adopted in 2016, when it went into effect. It gives us now, almost 10 years of history to talk about implementation, what went well, what are some challenges, and of course, with all these other orders, we have even more experience since they've been around much longer than the California's ERPO law, to give us a sense of what works, what doesn't work, where some of the challenges are. So hopefully some of those lessons learned can be shared in settings like I'm doing today. We have additional firearm prohibitions in misdemeanors, in felonies. We also have criminal protective orders that allow for firearms and ammunition to be restricted pending the outcome of a criminal case. There are mental health proceedings that impose restrictions as well. So both at the state and federal level in California and in many other states, and in Michigan, some of these things are true as well. You can check out how the interplay of state and federal law works, which I think is really critical to understanding, again, the importance of leveraging different tools, applying the right tool to a particular situation. I became interested in this during the years I was with the Judicial Council, which is the policymaking body for California's state court system, because when advocates in the gun violence prevention movement were pushing for the GVRO, a lot of us who were working in the courts were sort of scratching our heads about, well, what does this mean? What does this look like? Why is it necessary? And as we developed a better understanding of why it was so critical, we were in a better position to develop appropriate training, forms, rules of court, procedures to support the courts in being prepared for what was expected to be many more cases than it turned out appeared. And there's a variety of reasons why there has been some limited number of cases in certain counties and higher numbers in other counties. A lot of that has to do with culture of policing and how all of these other remedies are used. When you have a lot of tools to choose from and different approaches in different geographic areas, you can imagine, or may have experience with different folks taking a variety of approaches. So one of the things that's important for me to communicate is that in terms of measuring success, I think it's very important not to go down the road of measuring success by counting the number of ERPOs or counting the number of arrests. High number of arrests, high number of ERPOs, high numbers of DVROs doesn't necessarily mean we're doing a good job. That's one indicator. It can be interesting. It's an important data point, but we have to dig a bit deeper into understanding what is actually being implemented and whether or not it's being done fairly and effectively. SB 320, as I mentioned, is a comprehensive legislative package that took rules of court that addressed implementation of these firearm prohibitions in domestic violence civil cases and turned it into a statute. So I was one of the drafters who worked with the legislature on that piece of legislation. It deals with review hearings, reviewing files, and various implications for non-compliance. And one of the aspects of it that I think is so important that may seem obvious, but is not included in many relinquishment policies is that courts are required to tell people who become prohibited how they can comply. And we have anecdotally, we need to do more research on this, heard from judges around the state that have said that by creating local forms with specific information about what law enforcement agencies are taking firearms, how to turn them over to law enforcement, or how to turn them into a licensed gun dealer, those are the only two options in this state, that they have seen an uptick in compliance with the prohibition. So sometimes we run to compliance hearings, confiscation, search warrants, law enforcement involvement. All of that needs to be, again, another tool, a set of tools in the toolkit. But one easier way to go may be to also ensure that people know what they're supposed to do and how they can do it. And some number of folks will comply with those orders without the kind of intervention that I just described. We also have other policies that the voters enacted through Prop 63 that addresses firearms relinquishment procedures where probation would be involved in a criminal context, and rules of court that address review hearings and similar requirements in criminal proceedings. And we're working on some legislation now, SB 899, that will take the relinquishment procedures that are available in the DVRO context, the domestic violence context, and put them in place for these other orders. So I'm spending a significant time on this here at the beginning because I also want to note that we know what needs to be done and what makes a difference. So we have seen in California, not just as a result of these particular laws that I'm talking about, but there's a comprehensive set of legislative policies that, as compared to the rest of the country, we have seen the benefits of these policies in California in terms of reduction in gun-related deaths, suicide, and homicide. So we've seen a decrease in these rates. So we know that this makes a difference. And as Dr. Zioli and others have pointed out today, relinquishment is a big part of that. And having a whole set of tools in your toolkit is critical. At the Giffords website, giffords.org, you can read more about implementation. As I've emphasized before, I think that's really critical, especially at this important juncture in Michigan, where you have this opportunity with your newer policies and in thinking about future policies that you'll be considering to really make sure that the implementation is as robust and as fair and as applicable as possible, because we all know there are limited resources. And one of the things that can happen in this climate is heavy emphasis on the new, shiny, exciting legislation without an understanding of the need to implement policies across the board and make as much use of limited resources as possible, leverage those limited resources so that we're not favoring one set of policies over the other. I often talk about no matter what door you walk through when you become prohibited, if that's the context we're talking about, there should be fair and effective responses so that you get good information about how to comply. And anyone who's protected gets good information about what to do if there's a violation so that we can reduce risk. And law enforcement, the courts, anyone else involved, probation, social services, everyone has a better understanding that it doesn't matter if it's a gun violence restraining order or an ERPO or a domestic violence restraining order. We all have to be playing a role in addressing the increased risk when firearms and ammunition are available and haven't been appropriately relinquished. In domestic violence, this is particularly important for reasons that if you've attended other sessions, and again, I commend the conference on the attention that's being paid to this really important issue. We know that domestic violence is a particularly lethal combination when you mix in access to firearms and ammunition. So we know in Michigan, the Michigan rate of homicide and domestic violence cases involving firearms is higher than the national average. We know from various studies that when a firearm is present, a female victim of domestic violence who has a male partner is 5 times more likely to be killed. So simply removing firearms from that equation can increase the likelihood that those cases will not become lethal. We have over 1 million women alive today who have been shot or shot at by an intimate partner. There are 25 million adults who have been threatened, non-fatally injured by an intimate partner with a firearm, particularly serious problem in the United States as compared to other countries. So it's one of the reasons I think it's so critical that we be looking at the particulars of domestic violence as it's mixed in with firearms. One of the reasons this is important is because we sometimes hear from the gun industry that having a firearm is going to make you safer. And there are situations in which that may be true. But we know when domestic violence is being perpetrated, when families are in crisis, there's an increased risk. And of course, responsible gun owners recognize this and have joined with us in advocating for common sense gun laws that seek to reduce that risk. We want to ensure that the experience that women and children and too many others end up in, the experience they have when there are firearms in a domestic violence situation is changed. We know that over 2/3 of mass shootings have some kind of connection to domestic violence as well. So this is a problem that affects the broader community in addition to intimate partners, household members. And, domestic violence is a complicated problem, and I don't purport to be able to cover it all today. I have taught on domestic violence law for 30 years. It I think necessitates entire semesters and courses and training programs to address the complexity of how domestic violence is perpetrated. But some of the research that I find to be most succinct and useful in trying to understand what makes domestic violence particularly difficult for victims, survivors, and often for our system actors to address is some work that was done by Barbara Hart, who helped establish a lot of Pennsylvania's domestic violence laws and worked nationally as an attorney on these issues in the earlier days of the battered women's movement in the 1970s and beyond. And she talked to a lot of victims and survivors, women who described their experience as a rule-making experience. So this is across the board, across class, race, various different ways domestic violence was perpetrated. Some of what makes domestic violence challenging is how it is perpetrated in various ways, whether it's sexual abuse, emotional abuse, financial abuse, and physical violence. But the rule-making concept, sometimes referred to as power and control as well, is really important. And one of the first rules that consistently showed up in these cases is that the abusive individual decides they're the rule maker, so that there is one rule maker, one person who makes the rules. And the first rule they make is that I decide. I get to decide what the rules are in this relationship. So big red flag there, of course. Another consistent rule is you cannot separate, cannot leave. Another rule that shows up consistently, it's a characteristic in these cases, is that you can't tell anyone what's going on. And another one is that you have to be loyal. And when you decide to leave, when you get the resources to leave, when you finally, and usually multiple times, make a decision to try to separate, you can see that you are breaking all of the rules. If you're asking for a restraining order, you're asking someone else to be the rule maker. You are announcing to the world. Those proceedings are generally not confidential. You're describing what has gone on in the relationship. You are attempting to separate. You are no longer loyal. So it's a very dangerous time. All of the rules are being broken, and we have to recognize how dangerous a situation that person is in when they are going through that process. There's a wonderful piece written by Sarah Buell on addressing the various reasons why, in response to the question, why do abuse victims stay? And it provides all sorts of answers. If that question is coming up for you or people you work with, to be thinking about when you're in essentially a situation involving terrorism, why the very act of domestic violence creates a situation in which someone's ability to leave is severely limited. The real question is, why is the abuse continuing? Why does it happen? And what can we do to stop it? These kinds of threats, these rules are very much tied to access to firearms as well. So we know in situations in which there's a firearm present, it's very easy to directly threaten someone with a firearm as part of the abuse, or to just let them know and remind them that there is a firearm that's available for them to clean, have access to, or to use in this situation. We also have to have a deep understanding of the significance of domestic violence for children. The Trace has covered this extensively in an excellent piece that's available on their website, and that helps point out that whereas many in the mainstream press and many in the country may believe that School shootings are what we have to be most concerned about, and those situations are absolutely horrific, tragic, and we have good reason to be working hard to develop tools to reduce mass shootings, including school shootings. We again have to go back to looking as well at the toll domestic violence takes on children. One of the areas that I spent a lot of time on is what happens during child custody litigation in contested family law cases involving children. And there's been some review of news stories on this indicating that this is a phenomenon that's happening much more often than people realize, where an individual who has access to firearms is in a child custody litigation matter, kills generally his children and himself. So these are homicide, suicide cases, and sometimes the entire family. Again, we have to look at the gender, generally men, fathers. There are other kinds of increased risks when there are children not of the marriage who are, or the relationship in the home. But we have to, again, really understand what we're talking about when it comes to domestic violence and why it may be that we need specific tools that are domestic violence focused, and why we have to sort of parse the different ways that domestic violence is perpetrated as opposed to or compared with other forms of violence, so that we are bringing the most appropriate tool to bear in these kinds of situations. So this description here of an individual, a woman, a wife, a mom with 4 children, talking about her marriage. It included aspects of physical violence, being beaten, losing her teeth, almost killing their son, involving the criminal legal system, is an opportunity to answer some questions that sometimes come up about, well, why not just rely on the criminal legal system for domestic violence? If this is assault and battery, if it's this kind of level of violence, why wouldn't these people simply be arrested and prosecuted and held accountable for their actions? You can see here, as it's described, I've used this story in many different settings, and I ask people to consider, and here we're a little less interactive, but I'm asking you to just think about when you might imagine this is happening. You can see that in this context, she then asks for or applies for a protection order, a civil domestic violence order. And most folks who read this imagine it could be happening anytime, and certainly in modern times. But this is an excerpt from a story from 1868. Frances Power Cobb was a UK activist at the time in the late 1800s who worked to develop what we can now think of as the first framework for a civil order of protection approach. And this tool was necessary, this legal remedy was necessary because of the limitations of the criminal legal system. In this context, despite having had contact with jail, with law enforcement, he continued his violence, and it did not cover the kind of protection that she needed and the kind of issues she was dealing with. Financial concerns, concerns about limiting his access to her in the home, even after he came out of jail. So the protection order system was developed a long time ago to try and provide these kinds of remedies. A similar effort was undertaken in the late 1800s by Lucy Stone here in the United States. As Frances Power Cobb was working on this, Lucy Stone learned from Frances Power Cobb and, along with other advocates at the time, worked to try to develop that protective order system. We did not see adoption of a protective order system that did not rely on having to get divorced until the mid 1970s, and then firearms and firearm prohibitions, upwards of 20 plus years after that. Why is this important? Your PPO protections in Michigan, similar to other places, provide a robust approach. Not only might they be firearm and ammunition prohibiting, we're talking about going to civil court, which gives a victim survivor some greater control rather than relying on law enforcement or prosecutors. It can protect not just that individual, but the family, can limit access to certain locations. It can specifically identify and address physical abuse, prevent contact, including phone contact. It can include the need for someone to move out of a situation, provide protection against animal abuse or pets. It may include references to child custody and restrict access to firearms and ammunition. Now, we know that not all of the orders accomplish that. Dr. Zioli's research indicates that a significant majority of cases do not include orders regarding firearm prohibitions, but you can make those kinds of requests, and the court can issue those kinds of orders in certain situations. And again, this is where implementation and education becomes so critical, as well as possibly changes in policy. The idea here being that if we can limit access to firearms and ammunition in an ERPO proceeding, what can we do to reinforce or make more effective those same kind of prohibitions, along with specific remedies that are designed to address the kind of abuse that back in 1868 they were also dealing with, and that we know continues to be an issue. So it's sort of the combo platter approach, because if you only limit access to firearms and ammunition, that might feel good from a gun violence prevention standpoint, but it does not necessarily result in a victim or survivor feeling as though it's worth seeking the help if we can't also address all of the other ways, or at least many of the other ways, that they may be experiencing violence and abuse. We also have a lot to be thankful for around good, effective, fair law enforcement implementation of some of these policies. However, we also know that there has been some significant bias and, unfortunately, somewhat limited implementation of some of these policies in some instances. So domestic violence historically has been viewed often as a private matter, in part because that is what serves the purpose of the violence of the person who's being abusive, is to keep it as private as possible. And there are consequences around victim blaming when the abuse is made more public. So when we don't take domestic violence seriously, when we rely on newer legislation, like an extreme risk protection order in a domestic violence situation, the red flag of domestic violence itself can be missed and tragic outcomes can occur. So Jennifer Golan and Grace Oldham covered this in a piece in August of 2022 about what happens when law enforcement doesn't take domestic violence seriously. We also know from the story in Colorado, the second headline here, a lot of concerns with the implementation of the extreme risk protection order approach in Colorado, that when domestic violence is an issue, the ERPO law has not necessarily been as accessible to survivors as many had hoped. And I would argue that that was another moment in which we have an opportunity to focus again on another remedy, which is the set of domestic violence specific remedies that involve firearm prohibitions, so that we can understand the need for a more comprehensive approach. Again, having multiple tools available and then selecting the right tool for the right situation, and not putting everything into, for example, the arrest bucket or the ERPO bucket. And I've already mentioned Lisa Geller's really important research on the connection between domestic violence and mass shootings. We see that in many of the well-publicized mass shootings, like the Pulse nightclub shooting, the shooting in Sutherland, Texas, where the shooter there was able to get a firearm despite being prohibited, because the prohibition was not entered into the appropriate database, so that when he went to purchase the firearm, he was able to do so despite being prohibited. Again, another implementation issue where we have to recognize the dangerousness goes beyond the individual who might be protected in an order. That's important enough. And we know that there's implications for the broader community. This study, I like to highlight from 2015 that the ACLU did in response again to the question of, well, why not rely on law enforcement? And, please note my reference earlier to the longest standing ERPO example in the country in California, where 96% of them have been sought and were pursued by law enforcement. And we have seen in California that the ERPO provision has largely been an expansion of police powers as opposed to one that has been used extensively by family members. And I'll talk a bit about how family members have used them. And that is one of the reasons we don't yet have data that suggests that what some have thought would be a concern that somehow it would be racially biased as well. It may be in the sense that we have seen some indications that in situations involving perceived dangerousness, there may be greater reliance on carceral approaches, use of criminal remedies in cases involving people of color, less reliance on the GVRO in situations involving people of color, and greater reliance on the GVRO in cases perceived to be dangerous, but not as dangerous, involving white perpetrators or potentially dangerous folks. So our perceptions of dangerousness are infused by race and racism, structural racism and bias in this country, as well as issues related to gender. In this particular study that the ACLU, or report that the ACLU issued, they were trying to find out about why survivors might not call law enforcement. Why would they want to either pursue a civil legal remedy or stay clear of any kind of court involvement at all? And it's important to note that while ERPOs are civil remedies, they can result in criminal consequences. They still rely on the legal system. And the legal system itself is sometimes fused with perceptions of law enforcement as well as unfairness in the courts. So it doesn't always work to try to convince people that the civil remedy is going to be more effective than the criminal remedy or fairer than the criminal remedy. At the same time, what the report indicates is that survivors, not surprisingly, were looking for some kind of other punishment or outcome. They were not necessarily interested in separating, which lends itself to something like, well, do you use an ERPO to remove firearms and ammunition when a domestic violence situation may not result in separation? The couple, the family's trying to stay together, but perhaps firearms could at least be ordered to be removed during that period of time. At the same time, a lot of concern about being involved with law enforcement because of concern about losing control of the process, and concerned about how complicated the system was and that it would be traumatic in and of itself. So some things to think about as we consider why people may or may not want contact with the system, whether it's criminal or civil, but certainly as the ERPO develops in Michigan, how it will be shaped and understood in different jurisdictions. You may want to think about creating something like this. This is just a rough and dirty chart I put together that reflects some of what we have found useful in other jurisdictions. That is to put together a comprehensive one-pager, perhaps a chart that shows different remedies and why they're necessary, different tools that may be available. You can see here my suggestion that you include what your PPO allows for, who can obtain it, what firearm prohibition is included, whether there are relinquishment procedures. You can use this to highlight what might be necessary in terms of future legislation, and then why a particular remedy may be more limited in some instances. So for the PPO for domestic violence, for an example here, you may not have the same relinquishment processes that are being developed by the court rules. At the same time, you may have more comprehensive set of remedies. And again, to draw attention to the at least discretionary nature, although the language of your law also suggests that upon request, And with the right evidence being produced, you should be seeing some more firearm prohibiting remedies in your PPO matters. You have your new law going to effect with respect to state domestic violence misdemeanors, which is more limited in terms of time than the federal law, but more expansive in terms of who's covered. You can list out the ERPO requirements and understand how that compares to domestic violence restraining order. So something like this, a one pager that summarizes it, and I'm happy to make this available if you want to reach out to me at my email. And I've included some other information on the one pager as well as an example of what you might want to consider. Of course, you're interacting here with federal law as well. We have to remember that those tools are available. Even though we don't have relinquishment procedures, I always like to remind people that you're still not supposed to have a firearm under a whole bunch of other circumstances. And so the more information we can get out to help people do the right thing, comply as may be appropriate prior to enforcement, I think it's really important. We're trying to reduce the time between when someone becomes prohibited and when they actually comply, because that's such a dangerous period. Once they've been told they can't have firearms and then there's no enforcement of that, it undermines the entire court order, which is something I like to remind judicial officers of. Most judges don't want to put on the robes and sit up in their courtroom making orders that are going to be undermined and further erode public trust and confidence in our system. So you are prohibited for life if you're convicted of a felony, and on many of these other circumstances as well. Mental defective, of course, is in quotes because that's the archaic and biased language that's still used in the federal law. But that has to do with being admitted and evaluated in a mental health facility, resulting in a prohibition or a disability around firearms rights for life. And then specifically for domestic violence, the misdemeanor crime of domestic violence, lifelong prohibition, if the conviction matches the definition. And under G8, while the domestic violence restraining order, by definition, is in place. So not all PPOs, not all domestic violence civil orders are covered, but many are. And of course, we've been hearing a lot this past year about Arlington, Texas. Arlington, Texas first made the news when they very proudly were talking about innovative approaches to solving gun crimes, which included arresting this individual after he shot up Arlington, Texas, Mr. Zaki Rahimi, after he shot up a Whataburger restaurant, shot at a government official's car, shot up a car accident scene. Before there was U.S. versus Rahimi, the paper and law enforcement were talking about how useful it was that they had used certain tools to identify this individual to eventually obtain a search warrant and go into his home and remove firearms. While there's much to be said for reducing that kind of perpetration of community violence and addressing the threat head on, nowhere in that coverage did it address the fact that this individual had actually been prohibited long before this shooting occurred, and that no effort had been undertaken to obtain or have him relinquish the firearms that he held at the time he became prohibited, at the time of the state domestic violence order. That federal prosecutors and law enforcement got involved and pursued this matter, not for domestic violence. Mr. Rahimi was not prosecuted for a domestic violence and firearms incident. He was prosecuted for having a firearm in violation of a domestic violence restraining order as part of the violence he engaged in against the community. While he's been in prison, and appealing his case, which is before the Supreme Court, this aspect of his case with respect to 18 USC 922 G8, he wrote a letter about his experience and how he vows never to have firearms again. But one of the things that he tries to avail himself of is the notion that You have to understand why I had firearms. I had firearms because I was trying to protect my family. I'm trying to do the right thing by my family. So I should have been allowed to have those firearms in my house to protect my family. And I think it's so important to understand that concept, and how appealing that is to many people in the United States, that you have a right to defend yourself and protect your family. And we have to remember that Mr. Rahimi was prohibited because he had done harm to his family members, to the mother of his child, to their child, and that the court had found enough evidence there that he was a danger to his family, and that is why he became prohibited. These are the messages we have to get out so that we understand why we have to have these various tools available. In Judge Ho's concurrence, we see a lot of evidence of some of the bias that goes into preventing us from adequately addressing domestic violence and making full use of the tools that are available. It is often perceived to be such a big deal to take firearms away from someone, a man, who simply got into some kind of fight with his wife or girlfriend, and to interfere with his freedom in that way. And these are very gendered notions. There are also notions of who looks like a victim. We know too often women of color are experiencing violence in our court proceedings. Our gender bias studies in our courts that happen nationally in the 1980s and early 90s indicated that many women of color are not perceived to be victims or in that much danger, and that too often many white male perpetrators aren't perceived to be dangerous, again, basing notions of dangerousness on stereotypes and biases. We see in Judge Ho's concurrence some of these ideas that somehow restraining orders would just be handed out like candy, that we have to be very careful. He's suggesting, given how easy it is to make these claims, to take away firearms from somebody who's merely engaging in some kind of domestic squabble. So it's a wonderful tour of this horrifically biased notion around how dangerous domestic violence really is. So, in considering what the best tools might be, we have to be thinking about, will this approach actually prevent the violence we're talking about? In some instances, arrest, prosecution, and incarceration, despite the violence that's inherent in those proceedings and in prisons and jails themselves, things that we need to work on, because perpetrating additional violence against people who have experienced harm and perpetrated harm is not going to result in significantly changed behavior. But sometimes that separation is critical. So calling for civil tools in those instances may not always be adequate. We also have to think about confidentiality. To what extent are these proceedings confidential? And I've seen calls for ERPO proceedings to be confidential while we still allow domestic violence cases to be held in open court. And to be more consistent, to think through the kinds of crises, the mentions of mental health issues, concerns about the privacy show up in all of these proceedings. So what can we do to create more consistency, that one policy is not more favorable than another? Ask ourselves who has control over the process and make sure that survivors, those most directly harmed or at risk, have a lot of control over the process so that we don't have law enforcement, for example, deciding that an ERPO is appropriate and not getting a survivor connected to safety planning resources and interfering with their autonomy, the victim survivor's autonomy. How are violations handled? You want to see more consistent and fair approaches, not just take risk of mass shootings or suicides more seriously than domestic violence. And what kind of approach might be most comprehensive? So it seems like the folks that I've heard from today and that I've worked with for a number of years in Michigan and elsewhere are well aware of some of these concerns. But I just want to highlight again why sometimes we've seen in implementation a greater emphasis on ERPOs in domestic violence cases than I think is warranted. We have to remember that every time a survivor goes to court or seeks help and violates those rules I talked about earlier, they're at risk. So we have to just think about these tools really carefully. This is not just filling out a form at an administrative agency. This is going to court, proving your case, testifying, and having significant limitations on your freedom occur as a result. If you decide you want ERPOs and DV or PPO proceedings to happen, you can increase risk significantly. So try to leverage the tool that's most efficient and most applicable in these high risk situations. Remember that these prohibitions can be included in domestic violence orders. And remember that ERPOs don't name protected parties. There's been a lot of confusion about that. So I think it's important to highlight that. They are really largely designed for suicide and mass shooting threats, and we have seen reduction in risk. So they are important tools. They just may not be the only or best tool. And remember that we don't have federal firearm prohibitions in ERPOs at this point. We've seen them used by law enforcement in combination with arrests. Sometimes that's really helpful, and victim survivors appreciate that because there's a reduction in risk. But remember to keep their interests in mind. We've also seen them used as someone's admitted and maybe not evaluated or not subject to the firearm prohibitions in mental health proceedings. Co-responder models can be very helpful in that case. Again, we've seen them used to some extent by family members differently in different parts of the country where other kinds of restrictions weren't necessary. Maybe there isn't abuse or violence or threats. Maybe they don't have the right relationship. And again, when we have situations where federal law may not be applicable. So we don't want to just jump into the notion that it's always the best way to go. Just check the chat for a moment. Yeah, if you, I'm going to stop in a couple minutes. So if there are questions, I'd be happy to take those as well. Making sure you have policies and procedures, may or may not be able to get everything through the legislature immediately, but that doesn't prevent anyone from developing appropriate protocols and procedures in your local community. Develop, I'll show you an example of a brochure so that law enforcement and others, co-responders perhaps, can provide information at the scene of a crisis. Make sure that no matter what position you're in, if you're serving people in crisis, or people may be running up against these kinds of issues, if you're a faith leader, if you're working with schools, in counseling, in other environments where you may encounter people who are seeking help, to be engaging in these critical conversations about firearm access. And I have various resources available if you want to contact me about ways to ask the right question. Asking, do you own firearms, is generally not the most effective way to go. So figuring out how to have effective critical conversations and build trust so that you can bring the right tool to bear. And let's be thinking about all the different ways violence is perpetrated, not just firearm violence, because that is a tool of violence, but so are other methods of keeping somebody controlled and harming them. And we don't want them hurt in any other way. And we want them to feel that they can get the right kind of help. We've got to address the biases that prevent us from taking domestic violence seriously in some instances, or taking it seriously in other cases based on inappropriate factors. So consistency, avoiding bias, listening to victims, survivors is all a critical component. Giffords has created this pocket-sized brochure. I'll show you an actual example. This is just a PDF. It's a little foldable brochure. It is available to be copied. This is relevant most specifically for California, but I encourage jurisdictions to develop this. It's available in Spanish, English, and in simplified Chinese characters for free around the state. And it provides an example of the range of tools. Rather than how to get an ERPO, it talks about how to get help when someone may be a danger to themselves or others. And it might be you call a hotline. It might be you go to court. It might be that you get an order. It might be that you call law enforcement. It might be that you call social services. It might be that you reach out to find a counselor or a shelter. Making sure people know that they have a range of options available to them is really important. Another resource I wanted to emphasize is voluntary offsite secure storage. We've talked about prohibitions, but there's also an opportunity that organizations like Pierce's Pledge, piercespledge.org is working on, which is encouraging family law attorneys working in child custody litigation to have conversations with their clients and ask them to remove firearms, even if they're not prohibited, while the case is pending at the very least, because of potential for suicide, accidental shooting, and other harms associated with firearms being in the home when there's a crisis going on. This is a picture of Pierce, who was 9 years old when his father shot and killed him in his sleep, and then turned the gun on himself and died by suicide. He and his ex-wife, Leslie Hugh, had been involved with child custody litigation for a number of years. And despite his mental health issues and emotional abuse at the very least, probably should have been prohibited. However, he wasn't. And if the family law attorneys in that case had a requirement that no firearms be continue to be owned or purchased, folks may have been in a better position to reduce the risk here for Pierce, and he may still have been with us. So I work closely with Leslie Hugh and Pierce's Pledge on that issue as well. So talking about voluntary offsite storage when a family is in crisis is yet another way to go. California created this resource, endinggv.org, just to try and separate out extreme risk protection orders from domestic violence civil orders, and to give people some tools to assess what's the best tool to be used in a given situation. So you may want to check that out and see if that's something of interest that could be replicated in your state. And I worked on that with the state partnership to end domestic violence. The implementation page at Giffords has a toolkit, checklists, examples of how local communities can come together and work on implementation. So I encourage you to check that out at the Giffords.org site. You can look for the implementation toolkit for gun safety laws and learn more about what implementation looks like. And then I am happy to answer questions. You can reach me at juliafweber.com. And I'm happy to talk with you now. So thank you for your attention. Let me see if we have questions in the Q&A. No open questions. Anything else anyone wants to chime in about? Let me look at the chat, see if I have anything there. Anything else has come up for anyone as I have been talking? You can put your questions in the chat. Any thoughts, concerns, anything else? Well, I am happy to answer questions. Like I said, let me see, there's something here. Thank you so much. Well, thank you. Thank you for your attention. Again, you're in such an important moment right now with the adoption of these laws. One of the things I've seen is there's a great necessity to be enthusiastic and focused on the importance and value of the laws while we're advocating for them. What we want to avoid is being so focused on one remedy such that we end up not fully implementing all of the other remedies or not taking full advantage of the other tools. Is there any reason not to file for an ERPO and filing for a PPO if there are firearms involved? As the PPO firearm restrictions will not be enforced, but the ERPO should be. Thank you. So let's just start with that. That would be increased risk. You have prohibitions that you can ask for and that can be followed. And if that's not happening, please, please, please work with your jurisdiction to change that, because that's multiple appearances. That's multiple risks. the whole idea is that we have comprehensive domestic violence firearm prohibitions. Now, if for some reason the relationship isn't covered, perhaps there's a reason to do that, but think that through very carefully. And I would say work harder on ensuring that your existing prohibitions, your firearm prohibitions in your PPO cases are included in your PPO orders so that a victim survivor does not need a separate order, which can create higher risks, inconsistency, erode public trust and confidence in the system, because you can see that you can ask for those orders. So we want to streamline, not duplicate unnecessarily efforts. And when we say the ERPO restrictions will be enforced and the the PPO orders, the DV order may not be, very concerning. We should see consistency across implementation of all of these policies. And I would not assume in a jurisdiction that is not enforcing DV orders, I'm going to be concerned about the ERPO orders as well. Unfortunately, I have heard from some law enforcement where they're petitioners that they are able to implement them when they take it seriously enough that they're the petitioners. We've got to push back on that and hold our public officials accountable for taking all of these forms of violence seriously. So there is reason not to go for both if it's going to increase risk, decrease public trust and confidence, and create inconsistency. Has there been research on the frequency of which LEOs who are filing ERPOs and DV cases are working with the victim survivor and filing versus filing separately? I'm not aware of published studies or articles addressing that in terms of any real research. I know we have those conversations all the time around implementation. We know that a significant portion of that 96% of law enforcement petitioners in the California research pursued them because a family member, a victim survivor, came to them and said, I'm concerned about this person, and I'm afraid for myself or others. In some number of those cases, it may have been appropriate for them to consider encouraging the victim survivor, if there is one, to get an order that was more protective of that individual, or if that reporting individual is not a victim survivor, but was seeking some way of preventing harm to that individual or others, then pursuing the ERPO would make a lot of sense. So we know that law enforcement is often relying on hearsay or input from others when they're pursuing these matters. The question is whether or not the reporting individual was apprised of everything that would happen. For example, I have a situation where we have an individual who reported concern about another individual who had threatened harm to an institution. Law enforcement pursued the ERPO against them. This is not in Michigan, of course, another state. Pursued the ERPO against them. There was no protection for the reporting individual. And now this individual who is restrained from having firearms but has not yet complied, they're appealing their situation. And the order was not in effect temporarily while the appeal is going on. They have threatened the individual who made the report. And everyone's trying to figure out, how do we protect the individual? Now they may have to go get another order. So we have to be thinking carefully about the individual who is making the report as well. I think that's it. So we are, I think, at time now, or just another minute or so. Please feel free to reach out, julia@juliafweber.com. Thank you all so much for the good work you're doing, for the time you took today, and for this important conference. I look forward to continuing to do work with you all. Take care.